EB1, Employment-Based Green Card for Multinational Managers and Executives on L1. With the continued growth of the global economy, many companies are moving their senior personnel around the world to where they are needed the most. This includes transferring managers and executives to the U.S. to lead their company's U.S. operations. Many of these managers and executives contemplate obtaining U.S. permanent residence, a green card, either to minimize the hassles associated with having to renew their non-immigrant status, or simply because they intend to remain in the U.S. and eventually become U.S. citizens. Those that are coming to the U.S. using the L1A intra-company transferee visa for managers and executives are on a direct track to qualifying for EB1C, the multinational managers and executives, employment-based green card. The EB1C closely resembles the L1A non-immigrant visa in its basic requirements. Therefore, many people who qualify for an L1A visa also qualify for EB1C status without having to undergo the labor certification process. While the L1A visa provides an easier path for those interested in filing for permanent residence under the EB1C category, L1A status is not a prerequisite for EB1C eligibility. Moreover, L1A approval does not guarantee approval for the EB1C for the same beneficiary. Rather, an approved L1A simply indicates that the person has met the initial prima facie evidence of being qualified for an EB1C green card. Let's compare the L1A and EB1C requirements. The EB1C employment-based immigrant visa and the L1A non-immigrant visa, both for multinational managers and executives, share the following requirements. The U.S. petitioner is a parent, subsidiary, or affiliate of a company in another country. In the 3-year period immediately preceding the filing of the petition, or if the beneficiary is already in the U.S., his or her entry into the United States, the beneficiary must have worked for at least 1 year overseas with the parent subsidiary, or an affiliated company of the U.S. petitioner. The main difference between the non-immigrant and immigrant categories is that the L1A visa allows persons who were specialized knowledge workers in their home country to transfer to the U.S. as managers or executives. In contrast, the EB1C category requires that the beneficiary's position at the qualifying overseas company was executive or managerial. In both cases, the overseas managerial position had to be more than a first-line supervisor. L1B specialized knowledge employees generally do not qualify for EB1C unless the petitioner can show that the beneficiary served as an executive or manager for the company abroad, and that the position offered in the United States is executive or managerial. Thus, an L1B can only qualify for the EB1C green card if he or she also qualifies as a manager or executive, in addition to having specialized knowledge. Let's look at an example of this last situation. John entered the U.S. as an L1B with specialized engineering knowledge of a bridge building process not in common usage in the U.S. After being here for 2 years, the company decided to keep him here on a permanent basis. Since he was a project manager in charge of specific bridge projects in New Zealand before coming to the U.S., and he was the West Coast manager for all bridge projects the company had undertaken in the U.S., he was considered a manager both overseas and in the U.S., so he qualified for permanent residence under the EB1C category. Being and staying in business, another requirement. One additional requirement for both the L1A and the EB1C is that the petitioning company must be, quote, doing business, end quote, as that term is defined by the U.S. CIS, for at least 1 year abroad and in the U.S. before applying. However, under the L1A, there is a new office exception to this rule, which allows the petitioner to show that 1, the U.S. company has secured sufficient physical presence to do business, the beneficiary meets the 1-year continuous employment abroad requirement, and the newly formed U.S. company will, within 1 year, support an executive or managerial position. The new Office L1 petition will only be approved for 1 year. At the end of that first year, the company will need to file an extension showing that the business is active, fully operational, and requires a manager or executive. This typically involves showing that the company has expanded its U.S. revenues and has hired additional personnel. The first year for a new L1 office is a conditional period, after which the company has to show that it is serious about being in business in the U.S. After this extension is approved, only then can the beneficiary pursue an EB1 Green Card. Unlike the L1 visa, the EB1C Green Card petition does not have an exception for companies that are launching a new office in the U.S. Instead, it requires that the U.S. company have been in business for at least 1 year before the petition is filed. This limits the new office L1 beneficiary's ability to immediately file for an EB1C petition. Those beneficiaries who have come to the U.S. to open a new office must wait until the 1 year has passed and the first-year extension has been approved. In addition to the requirement that the company be in business in the United States for 1 year, the petitioner must also show that the company abroad will continue to operate, even after the beneficiary has transferred to the U.S. This is true in both the EB1C L1 visa context, and is especially true when the transferee is a major force in the success of the overseas company. Under the L1 visa category, if a company ceases to operate in the foreign country, the L1 visa status is invalidated and the beneficiary must change his status in the U.S. to another classification or leave the U.S. Under the EB1 category, the halt of operations by the foreign company before the beneficiary obtains their green card would lead to USCIS revoking the underlying I-140 and denying the permanent residence application. For these reasons, the continuing operation of both the foreign and U.S. offices is an ongoing requirement for both the L1 and the EB1C categories. Concluding here, qualifying for the EB1C Multinational Executive and Manager Immigrant Visa category is advantageous because no labor certification is required for the beneficiary. Labor certification is a tedious process involving several additional steps. The company is required to conduct a test of the labor market through a recruitment process or procedure to determine if there are any minimally qualified U.S. workers that are ready, able, and willing to fill a position. Since a majority of the time the position would be that of a senior manager or executive, such recruitment would neither benefit or be taken seriously by the company. The EB1C category is designed just for this scenario, allowing multinational companies to transfer senior managers and executives to the U.S. with only a job offer and without a need for the recruitment. However, qualifying for the EB1C immigrant visa is not a simple task. As outlined in this article, obtaining a prior L1A approval suggests that the beneficiary will likely also qualify for an EB1C, since the qualifications for the two visa categories are very similar, but it is not a guarantee. The petition preparation for this visa category is quite complex, requiring extensive analysis of the underlying facts. For these reasons, VisaPro highly recommends that anyone interested in pursuing an EB1C consult a highly experienced attorney who has successfully handled EB1C immigrant visa petitions in the past. Despite the complexities of an EB1C petition, we have successfully helped many managers and executives obtain their green cards through this category. We will be glad to help you with the EB1C process if you qualify. To determine whether you have what it takes, please register for a consultation with one of VisaPro's senior attorneys, and we will gladly analyze your qualifications and options in detail. Also, you can contact VisaPro if you have any questions regarding any other types of employment-based petitions. Our experienced attorneys will be happy to assist you with these as well.